Good morning, Your Honors. Can you hear me?
Loud and clear.
May I proceed, Judge?
Absolutely.
Doug Ackerman on behalf of the appellant Cutrale Farms, Inc., Your Honor. There are three basic grounds for reversal that we are urging this morning. First ground is a conflict between the notice provision in the prime contract and the multiple notice provisions in the performance bond. It is our opinion that these provisions are irreconcilable and that at a minimum they are ambiguous. In either case, Cincinnati loses. The law in Florida is quite clear that all ambiguities are construed against the surety, and this procedure, as advocated by Cincinnati, is both ambiguous and, in our opinion, it's impossible to follow their argument that you have to comply with all of the notice provisions in both the prime contract and the performance bond. It's also worth noting that these are both documents published by the same organization, and yet there is no cross-reference. So if the AIA wanted an owner using the prime contract A201, one of the most common contracts in the entire United States, to also follow the notice provisions in the A312 performance bond, one of the most common performance bonds in the whole United States, they would have obviously included a cross-reference between the documents. They do not. So that alone is grounds for reversal without getting to point 2 or point 3. Point 2 is a very simple summary judgment ruling. The corporate rep for Cincinnati filed an affidavit in which he explicitly said, quote, "We cannot act under Section 5 without the receipt of documents to be provided by Cutrale." Well, Cutrale had no obligation to provide such documents. Therefore, the lack of a Section 6 notice, I'm sure Your Honors have gleaned that there was many, many notices. Cincinnati's position boils down to we needed one more notice. But even putting that aside, their own corporate rep made it very clear, we will not act under Section 5 without the receipt of documents. Cutrale was not obligated to provide any such documents. So that on summary judgment, that affidavit needed to be read in the light most favorable to Cutrale, and that alone is a ground for reversal. The third argument requires Your Honors to get into a rather small area of law, a rather very important area of law, and in our opinion, an area of law that is very much misunderstood. The overwhelming point is that the Florida Supreme Court's decision in Gibbs controls. The Florida Supreme Court's decision in Gibbs controls. It is a performance bond case in the construction setting, and it holds very explicitly that if there is a material breach, the surety must prove prejudice. That is the end of the third argument. The cases relied upon by Cincinnati, with all due respect, have ignored Gibbs. And I'm sure Your Honors are familiar with the thoroughness of published federal decisions, of which almost all of these are. You will look in vain to even find Gibbs in a footnote in any of those decisions. The federal courts were bound by the Erie Doctrine to follow Gibbs. They must follow Gibbs. They have not followed Gibbs. They have ignored Gibbs. They do not even distinguish Gibbs. It is apparent that this area of law, starting in about the mid-90s with the Southern Concrete case cited in our brief, went awry. And no one ever went back to the roots of what is Florida law, which is what controls this issue. And Florida law is the Gibbs case. Less egregious, but still egregious, is the complete ignoring of the Plowden decision from the 4th District in 1966. That decision was exactly on point. And it held that a surety who received no notice Again, Your Honors, this is a case where Cincinnati does not dispute we complied with the notice provisions in Section 3 of the bond. They want one more notice. In Plowden, it was undisputed that the surety got no notice, zero notice. And the holding in the case was that the surety had to plead that as an affirmative defense and still prove prejudice as a result of receiving no notice. Once again, the federal courts, and most of these decisions are federal, have completely ignored the Plowden decision. You will not find it distinguished. You will not find it cited. You will not find it referenced. It's just been ignored completely. And finally, we get to the third district's decision in Insurance Company of North America in 1997, which, with all due respect, that court missed Gibbs and missed Plowden. That case cites as the sole authority an appellate decision from Illinois on this issue. That's it. The third district, of course, was bound by the Florida Supreme Court and should have at least distinguished or certified conflict with the fourth district in Plowden, and it did neither. We don't know why, and we never will know why. You will see that the federal courts, while ignoring Gibbs and ignoring Plowden entirely, have latched on to that third DCA case, which is a very short, very thin reasoned case, which cites as its sole authority an Illinois appellate decision. Finally, we hope that Your Honors have latched on from the briefing to this remedy of total exoneration. It is a remedy unknown in my practice, which is all construction law, and in this law firm, which is all construction law, and we deal with every form of contract imaginable. Every other party to a contract has to prove damages which flow from a breach, except somehow the sureties. They get this get out of jail free card where they don't have to prove prejudice of any kind. Now, the options of the surety under the bond are not variegated. They do not have a wide panoply of things they can do. If you read the options in the bond, they all involve some form of spending money. They can either A, convince the owner to take the defaulting contractor back. They can B, prop up their own resources, cash, to pay to finish the job. Or C, they can go out and get other contractors and bring them in and tell the owner, we will pay them. So implicit in the federal decisions that the surety ought to get a complete total exoneration is the very, very, very false premise that the surety cannot prove its damages if it doesn't get the notice. Of course, the surety can prove its damages. All it has to say is in May of 2017, which is when this went down, I could have finished this construction project for X number of dollars above the contract price, because of course the surety gets the benefit of the remaining contract balance. It would even be appropriate for Your Honors to say, since you, Mr. Obligee, failed to give notice, we're going to adopt a judicial presumption that all estimates of the surety as to what it would have cost them to fix are reasonable. And you, the bad guy who didn't give the notice, or in this case, didn't give one of many notices, have to overcome that presumption. But what is the overwhelming point? It is very, very easy to get construction estimates from contractors and expert witnesses. Your Honors no doubt have all kinds of construction cases in front of you, and of course the circuit courts are loaded with them. This is an entire cottage industry of experts. They're all over the place. So the surety who didn't get any notice at all, period, could always come in and say, if I had gotten that notice and if I had elected to complete this job, I could have done it for X number of dollars in excess of the contract balance. They may even come in, and certainly wouldn't surprise us, and say, we could have done it for less than the contract balance. Very well. Present your experts, present your estimates, And by the way, when a contractor is being terminated or thought to be terminated, what is the first thing that everyone does, including the surety? They start running around asking other people, how much can you finish this job for? So not only is there a gigantic cottage industry on construction cost estimating, but the very impetus for the termination results in everyone trying to figure out how much money is it going to take to finish. So if there are no other questions, I will reserve the rest of my time.
Thank you, Mr. Ackerman. Mr. Brannick?
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick Humphreys and Bourbon, representing the surety, in this case, Cincinnati Insurance Company. Appellant has worked hard to complicate what I think is a very simple case. It's decided by the language of the bond and well-settled law. So let me take his points in order. First, there is no ambiguity in the notice requirements. Section 14.2.3 of the construction contract establishes Cutrale's right to terminate the contractor, but it clearly says that this termination is subject to the surety's rights. And of course, the surety's rights are established in the bond contract. So you have to go to the bond contract then to see how can Cutrale effectuate its rights against the surety. Under paragraph 3 of the bond contract, Cutrale is required to give notice to the surety of the termination. They did that, there's no dispute about that. That then gives, under paragraph 5, the bonding company the right to, in reasonable promptness, to decide what its options are going to be. Is it going to try to work with the original contractor? Is it going to complete the contract itself? Is it going to hire someone else? If Cutrale doesn't think that the surety is acting with reasonable promptness, it can put Cutrale on the clock, and that's what paragraph 6 is. It can say, Cutrale, it can say, surety, you've got 7 days to make your choice, and if you don't make your choice, you are in default, and at that point in time, we have all of our rights. That's what Cutrale never did here. It jumped the gun. Instead of giving, it gave its termination notice in paragraph 3 on May 16th. Instead of giving the surety its right to work with reasonable promptness, and instead of putting the surety on that 7-day clock, it jumped the gun and it hired its own contractor. That essentially prevented the surety from being able to exercise that choice. There's nothing ambiguous about any of this. The notices provisions in the surety contract and the original contract are completely complementary. We've got a case right on this point. It's the International Fidelity case, the AmeriCarib. It's a 2017 11th Circuit case. It's a Section 6 failure of notice case, exactly like this one. The court looks at the contract, it looks at the bond, says that they're complementary, finds nothing ambiguous about it, and releases the surety from its obligations. Then we have the many cases that I'm going to talk about in a minute that talk about what the appropriate remedy is. None of those cases, none of them suggest that there's any ambiguity. And as Mr. Ackerman has pointed out, these are very, very common contracts drafted by experts in the construction world. You would think that if there was a problem between the two contracts, we would have heard about it by now. There just isn't any problem. Their second point is that this was all moot because the surety was never going to do anything anyway. All the surety said is, we need these documents to help make our choice. And Cutrale responded by saying, okay, we're going to get you these documents. But then instead of getting the documents, they went ahead and hired their own contractor. If they thought that the surety was being unreasonable and asking for these documents, if they thought that the surety was acting too slowly, all they had to do is give their Section 6 notice and say, surety, you are now on the clock. You've got 7 days to do this. They never sent that notice. So there's simply no issue about the surety refusing. They were never given the opportunity to refuse. The final point is this point about what the appropriate remedy is in the event you fail to give this notice. And again, this is not complicated. The law is absolutely unanimous about this. Florida law says that the failure to give notice is a material breach It's a condition precedent, and it relieves the surety of its obligations. And there's very good reason for this. This is not just a notice technicality. They didn't just not give the notice. They didn't give the notice, and then they went ahead and jumped the gun and hired their own contractor who finished the project. And now they're claiming that they're due additional monies. It puts the surety in an impossible situation to say that later on the surety is supposed to come in after someone has already finished the contract for a particular price and say, oh, wait a second, we would have been able to do that more cheaply. That puts the surety in a very difficult position where it's very easy to argue that all of their evidence is going to be speculative. And the courts recognize the surety shouldn't have to be put in that position. The surety should have been able to exercise that choice. And if they wanted to complete the contract themselves, that way there's no question about it. Nobody is speculating about how much it's going to cost. We would know exactly how much it's going to cost. So that's why these courts apply these notice provisions very strictly. Again, the AmeriCarib case is right on point. It's a Section 6 case. It says that this is a material breach and it relieves the surety of its obligations. Now, these federal cases are not going rogue. They are basing their decisions on Florida law. The AmeriCarib case cites the Insurance Company of North America case, for example. That's the 3rd District Court of Appeal decision in 1997. And Florida law is on point. There are, I think, 2 really important cases. One is the National Gypsum case, which we didn't hear anything about, where the Florida Supreme Court in a case says that the failure to give notice is a material breach and relieves the surety of its obligations. I'm sure opposing counsel will then step up and say that National Gypsum was a payment bond case, not a performance bond case. But if you look at the language, the court specifically says that its reasoning applies both to payment and performance bonds. And that's exactly what Judge Schwartz, in his concurring opinion in the 3rd DCA, which was adopted by the Florida Supreme Court, says. And there really isn't any difference between payment and performance bonds in this context. The surety has not been given the option to exercise its rights under paragraph 5. Then we also have the Insurance Company of North America case. That's a 1997 case that counsel mentioned. The 3rd DCA clearly says that this is a condition precedent, and it releases the failure to provide notice releases the surety. There's also a 4th DCA case, the Current Builders case in 2008, a 1st DCA case, the Balboa Insurance case from 1979. The cases are unanimous in Florida. There isn't any conflict. They say it all goes back to this Gibbs case, 1952, Florida Supreme Court. The Gibbs case is not a notice case. It has nothing to do with failure to provide notice. It is also not a case arising under a failure to comply with obligations under a performance bond. In the Gibbs case, there was a claim that a very minor misstep under the construction contract in performing the obligations under the construction contract, not the bond contract, but the construction contract, should relieve the surety from its obligations. And the court in that case, in the Gibbs case, said, no, in that situation, surety, you've got to prove what your damages are. But that was not a case where there was, again, not a notice case and not a performance bond case. So Gibbs certainly doesn't apply to this situation. It's the Florida Supreme Court's decision in National Gypsum, and it's the other DCA decisions that apply here. The Plowden case, is pretty easy to determine why no one has been citing the Plowden case. The Plowden case relied on the Mall Industries case, which was one of the 2 cases that was up before the Supreme Court in the National Gypsum case, and the Florida Supreme Court disapproved of the Mall decision. So Plowden is based on outdated and irrelevant law. Since I've got just a minute, I thought, if I may, I'd like to just turn real quickly to our motion for attorney's fees. I wanted to make clear that in our motion for attorney's fees, we are not seeking fees under the statute 727-428. So the Danis Industries case is irrelevant. We are basing our claim for attorney's fees on the contract between the parties. 15.3.3 gives the prevailing party the right to recover fees. That's in the construction contract. That construction contract is incorporated by reference into the surety contract. the construction contract uses the very general terms prevailing party. It doesn't say anything about just being the obligee or the contractor. And
does it remind me, Mr. Bannock, does it refer to litigation over a breach of the construction contract or to enforce the construction contract?
It's got very broad language. I think I have it right here. It says any claim, dispute, or other controversy, if any claim, dispute, or other controversy in question is not resolved, it seems to be very broad in its language. There are Florida cases that say that if even in the surety context, if the contract has a prevailing party attorney's fee provision, it should be enforced. We have very sophisticated parties here. They bargain for fees. They should be awarded. So for all those reasons, we think that the judgment below should be affirmed and that the surety should recover its fees.
Thank you, Mr. Brannick. Okay, Mr. Ackerman, let's call it 6 minutes.
Thank you, Your Honor. Plowden cited a performance bond case in the exact same paragraph that it cited Mall Industries, and that's Equitable Fire and Marine Insurance Company. In fact, the appellee cited Equitable Fire and Marine Insurance Company. That is a performance bond case, and that cites Gibbs. So the suggestion that Plowden has somehow been overruled is wrong because it cites Gibbs. And it's also wrong because Plowden had both a payment bond claim and a performance bond claim. The payment bond claims relied on by Mr. Brannick, which from what I can gather were more than half of his cases, have nothing to do with a performance bond. We briefed that issue very, very thoroughly in our initial brief. There is not one word of response in the answer brief. A payment bond flows downstream to subcontractors, subcontractors, possibly even third-tier subcontractors, and suppliers to all of those entities. So a surety on a payment bond is in a radically different position than a surety on a performance bond, because they are getting a panoply of claims from various people along the construction chain, which they don't know at all. If they don't get the notice, they don't even know who the claimants are. That has nothing to do with it. A performance bond, as here, has one known obligee. So those cases are completely irrelevant and they should be totally ignored. Let's go through the bond and the contract, since appellee seems to think that they can be reconciled. Cutrale gave their first notice on April the 12th, 2017. And they said that that was under the bond, a section 3.1 notice. Now, what does section 3.1 say? Well, it gives the surety 5 business days after receipt of that notice to decide whether it wants a conference. And it gives the surety another 10 business days if they elect to have the conference after the additional notice. So that is a possibility of total of 15 business days, not including calendar days. Well, that's impossible to square with section 4.2.3, which says the owner may give 7 days, not 7 business days, 7 days notice, and then terminate. Well, it's obviously not reconcilable to say that the owner can terminate in 7 non-business days when the surety has up to 15 business days to decide whether it wants to have the conference and so forth. That's inherently irreconcilable. Number 2, if we follow the performance bond section 0.2, the owner has to send yet another notice, and this is the one that actually declares a default and terminates. Mr. Brannick said that was on May 16th. He erred. That was on April the 25th of 2017. But do I have to terminate twice? Because under the contract, I can terminate after 7 days of giving a written notice. But under the bond, I have to wait up to 15 days to terminate. And you can understand, and if you read these cases, you'll see Everyone in the surety business knows that this is the sword of Damocles. This is a shot to the jugular. This is total exoneration. So they love to play these notice games because they know when they get in litigation later on the merits, they can always fire this silver bullet at the obligee and say, aha, you didn't comply with the notice and you're dead. Absolute, complete, total exoneration. Don't worry about the merits of any kind. Now let's continue. Section 3.3 of the bond says I have to give another notice. Well, hold on a second. Under the contract, I was allowed to terminate the contractor. And what else am I allowed to do under the contract? Section 4.2.3.3, I'm allowed to finish the project. I hope your honors can assess the gravity of that given the surety's position. Their whole position is we should be able to finish the project. That's how we mitigate our damages. That's not what the contract says. It says under 14.2.3, after I give 7 days written notice, I may, the owner, finish the work by whatever means necessary. Well, hold on. I thought I had to wait 15 business days to have meetings with the surety. Then I have to send another notice under 3.2 that actually terminates the contract, which is inconsistent because I already terminated it under 4.2.3. And then I have to write yet another letter saying very unequivocally to the surety, I will pay you the remaining contract balance. Those cannot be reconciled. That is a sea of ambiguity, all of which should be construed against the surety. And in this case, look how egregious it is. The owner sends notices out from April the 12th until May the 16th. The surety never does anything except request documents. The surety in this litigation admits that paragraph 3 of the performance bond was satisfied and admits that the contract notice was satisfied. So what their position boils down is the obligee has to figure out how to reconcile all these notice provisions and give yet another one or face the prospect of the surety getting a total exoneration in court because these ridiculous provisions, which make no sense, were not followed exactly. And of course, they love to drag it out with letters and requests that plunge you further into doubt as to what notice do I have to give now.
Mr. Ackerman, you're at the end of your time.
I'm sorry, Your Honor. Thank you.
Okay. Thank you both very much. The court will be in recess for 15 minutes.